our team, Max Wistow, to my right, of course, needs no introduction. Eddie Parry, Alyssa Lemur, Benjamin Ledgeham, and Mike Robinson have been working with Max and myself to move this case along. And Max, if you'd like to open up.
Yes, I understand that there's an intense interest in timetables in this case.
Let me just ask you to speak up a little. Or
sure, I'll come closer.
Thanks.
I'll start over again. I understand there's a great deal of understandable interest in timetables in the case that we're talking about. And I'm going to try to address that as best I can from the point of view of what our task is. And when I say our, I mean the lawyers who are sitting here today. And let me make very, very clear what our task is. We are absolutely not involved in the RFPs, the RFIs, the awards, any of that, whatever. Our sole concentration from the time we've been involved, our exclusive interest has been to determine if there's a legitimate basis for a lawsuit against third parties who had involvement with the bridge. And we have been actively engaged in the process of trying to determine as definitively as possible before a final decision is made as to, number one, if suit is to be brought, and number two, against whom suit will be brought and for what. Since we've been employed, I believe the date was April 4th. It was early April. So we're talking about, we've been involved in this process now for, it'll be 4 months, I guess, right around now. That may seem like a long time for lawyers to be looking at a case to determine whether or not there's a basis to go forward. This is not a slip and fall at Stop and Shop. This is not a fender bender. This is an extremely complicated, very fact intensive and very paper intensive case. For example, so far we've been presented with well over 100,000 pages of documents involving very complex technical issues, engineering issues. And we're doing our best to try to come to a conclusion as to what we should do. Now, the governor has taken a hit in the press for not revealing the preliminary reports in the case. And I respect him greatly for that, because he realizes at this point, and has realized, that what's more important is to make sure that we're able to bring as efficacious a case as we possibly can, in spite of the cries to him saying, give us this stuff, give us this stuff. And by the way, we all very much, and I mean this, respect the role of the mainstream media to get information out to the public, as opposed to seeing it all on TikTok or something like that. So we welcome the opportunity to tell you exactly where we are today, to the extent we can, realizing that we're lawyers who don't want to do anything to compromise our case. Now, to give you an idea of how long something like this can take, in our experience, for example, 38 Studios, which is a case that I was involved in, it was many, many months after we were retained where we really felt comfortable bringing the lawsuit that we ultimately did. Same thing with the St. Joseph's pension. It was months that we did our investigation. So we're not in any way trying to delay this. We're trying to make sure we know what we're doing. Now, one of the points that needs to be addressed here is what normally happens in these kinds of cases. You need an expert, at least one expert, to testify that somebody involved in the matter performed below the standard of care that's acceptable for engineers, for designers, for architects, for that kind of thing. And you need that expert to say what the consequence of that failure to adhere to the standard of care was. What happened in this case? Assuming somebody was negligent, what was the consequence of it? And that's a concept that a lot of people have difficulty following. You assume if somebody's negligent, they have liability. If somebody performs under the standard of care, they have liability. That's not necessarily true. I'll give you a very homely example of what I'm talking about. So if you go to a doctor and he examines you and he gives you a complete clean bill of health, and you walk out the door and drop dead from a coronary, it may be that he missed it, but that even if he did what he was supposed to do, there was nothing that could be done in that period of time. So we're looking to see if somebody not only, quote, messed up, but what was the consequence of that? And that is a rather complex issue that we're trying to address. Now, when do we believe that we're going to have a conclusion to our inquiry? And our best judgment at this point, that absent some startling revelation, which is always possible because we're still reviewing documents, our best judgment is by early August, we will be in a position to definitively recommend whether or not to bring a suit, and if so, to whom, against whom, and for what. I guess one of the questions that came up in the press was the fact that we had sent letters out to general contractors. And this was some time ago, soon after we were retained. And I want to explain what the purposes of those letters were. I'm sure all of you have access to them. If you don't, let us know. We'll send you copies of what went out because they've become public. We were extremely clear, or as clear as we possibly could make it, that the recipients of these letters should not interpret it to mean that they are necessarily going to be defendants. We say that flat out. And one of the reasons we sent the letter out was there may be people involved in the transaction, the transactions over the years. We don't want them disposing of records that may be very important to us. They may have a regular records disposal process that they go through and legitimately get rid of records. We wanted to say as soon as possible, keep your records. That's what's called an anti-spoliation letter or a litigation hold letter. So, and we also said in there, you may want to notify your insurance company. Some people seem to have interpreted that to mean that we're saying you're a high prospect for getting sued. That was not the purpose of it. And let me tell you what the purpose of it was. Sometimes insurance companies are not too eager to defend people. I hope you haven't had the unfortunate situation of having an insurance company come to you and say, we're not going to cover you for various reasons. We didn't want to be in a situation where some insurance company later says, you should have told us about this litigation hold letter. And because you didn't do it, you didn't cooperate, and we're not going to cover you, which makes things more complicated. So what I want to say, and I want to emphasize, is those letters try to make very clear, I won't bother to read you the exact language, but it said, please don't interpret this to mean that you're necessarily going to be a defendant. So what I am going to do is, when I get questions from you, is I'm going to be candidly sort of cagey about what my answers are going to be, because what we're trying to do is ultimately get the maximum recovery that's conceivable for the state of Rhode Island, because this is obviously, I don't have to emphasize what a major hit this will be on the taxpayers, even with the contribution by the federal government. So with that, unless anybody has anything they want to add to this, what are we?
We'll open it up.
What
Yes.
do we give a chance?
Can we maybe go in an orderly fashion, or you guys decide among yourselves who recognize one person, so we're not picking and choosing? You guys work it out.
Max, is this the most complex case that you've ever dealt with?
It depends what you mean. I would say factually, it's very, very complex. Legally, I don't think there's that much complexity to it. Some of the cases we've been involved with, multiple legal issues, very unusual legal issues. Here, I think this is analogous, in a way, in my view, to a suit against a doctor, a suit against an accountant, a suit against a lawyer. These are suits against engineers and designers. And I don't think there's any huge legal issues that are going to be addressed.
Quick follow-up. So in terms of assessing the documents, is this mostly an issue you need more time? It's just a capacity issue that there are so many documents and you need more time to make your decision?
And also, we're consulting with the expert that was originally hired here, because we're not going to tell you that any of us are experts in bridge building. We need the assistance of the expert, and he continues to work with us, and we've been able to further our inquiry to the point where I really do feel comfortable saying that in early August we should be where we want to be.
Well, Max, like you said, you are 4 months into this case. We're over 200 days into the closure of the bridge. Do you and your expert have a better sense as to what has gone wrong?
Let me put it this way. I'm going to answer yes, but I'm not going to go beyond the obvious question is what is that sense? The answer is yes. We are approaching that point. As I said before, I'm going to be cagey. I'm not going to reveal the details of what the expert is telling us and where we are. Just not going to do it. Not out of disrespect to the public or their right to know, but my principle, not my principle, my exclusive purpose, along with the people working with us, is to maximize the recovery. And as a lawyer, I think that signaling particulars is not a good idea at this point.
Let's
Two-part
have staff and then Ryan.
People, just so we don't, I mean, I know Tim White's not here
And
today.
the
but-
staff and then Ryan, okay?
Excuse me, it seems like there's two different things you're trying to figure out. One is what happened and what went wrong. But as you just acknowledged, just because someone messed up doesn't mean they're going to be sued. And there could also be people who messed up who cannot be sued because they work for RIDOT. There's no money to be recouped from that. So are you going to release publicly what went wrong regardless of whether you're suing those people?
The answer is this. If we decide that there's not going to be a suit, if we decide that, the decision of whether or not to release it will be the governor's, not ours. Our role would be ended if we said we're not going forward. If we bring a suit, it's our position we're not going to reveal the preliminary work of the expert or the final work of the expert until we're required to do so in the court proceedings.
What if you bring a suit against some defendants, but you have found fault with other people who are not being sued? Will that see the light of day?
That's an interesting question. I think the answer is going to be, will it see the light of day at a time when our expert's report has to be disclosed to the other side? If that is discussed in it, that here's a guy who messed up, an entity that messed up, but it didn't have any consequence, it may be in the final report. If that's so, I know he wants to say something. If that's so, and if there's a suit, that final report will be, by definition, be turned over to the defendants. They'd be entitled to it.
And I think through the process, information that you all are interested in will come out through the litigation process. As Max says, should we go in that direction? As I think he's also said, we expect to be in a position in early August to make that decision, go, no-go, probably more likely than not that it's go rather than no-go, and that the process will bring out a great deal of information that you and the taxpayers are interested in and entitled to see.
So we'll go to Brian and then Bill, please.
Max, when you say the expert you're talking to, is that, just to be clear, is that the same as the group that did the forensic audit for the state?
Yeah, the answer is yes.
Just to be clear, is that complete, the forensic audit? Because I know that's what,
No.
when you say the governor had reviewed.
The answer is there is no final report at this point. And that's what we're working very, very hard to get, and which we're present belief. And I don't want to appear before you at some future time and say we're going to talk about a continuance of this. We're going to do everything we possibly can to decide where we are at the beginning of August.
So just to be clear, the forensic audit is not complete. Do you know what the delay is? I mean, the original thought from the governor's office was that was going to be done very soon, but then it was going to be, then he said it would be handed over to you and he didn't want to compromise.
What you have to understand, the document we're talking about, and that you've been trying to get, is it's called a preliminary, but it's actually entitled that. So there was additional information that was required, and that is coming. And not only is coming, but has come since the original preliminary report was issued. So I guess what I'm trying to say to you is we're in a very unusual situation where we have something that normally is absolutely privileged from disclosure. For example, in the AARP, APRA rather. I'm thinking about I'm getting so old, I'm thinking about all the mailings I get from the AARP. But be that as it may, these things are privileged. And yet there's this big legitimate request for it, and the governor has decided correctly, in my view, that what's more important here is, are we going to be able to do a successful lawsuit if that's what's warranted? And if in that decision, really, as to whether the release of this or not is going to be harmful to that, is something best left to the lawyers. And I respect them for that enormously.
I want to go to Bill and then Steve and then Pat.
Two questions first building off of Steph and Brian. The information contained in the documents you've received, the final report, anything that you're working on right now in layperson's terms, that could be subject to parallel or future criminal proceedings, additional legal proceedings, and disclosure would be mandated. Is that a correct assumption that everything you're doing right now, even if it doesn't result in a lawsuit, any additional investigations, you would have to turn that material over?
Wait a minute. Are you saying if we were subpoenaed, say?
Let's say you're subpoenaed or otherwise.
Right. If we were subpoenaed by competent authority, of course we would turn the documents over.
So this investigation, while the end game within your purview is lawsuits or not a lawsuit against contractors, information contained therein could be used in subsequent lawsuits, in a civil case, or potentially criminal charges if something were disclosed that flagged the appropriate body. Is that fair to say?
Yeah, well, I'll give you an example of where that happened. That happened in 38 Studios. Everything that occurred in the civil case, everything became public. There was no exceptions, whatever. Once the lawsuit started. Much of the material that we produced was turned over to a grand jury, which we had nothing to do with. We don't prosecute, in Rhode Island, we don't have citizens prosecuting criminal cases. That's the Attorney General or the U.S. Attorney. And in this case, the attorney, in the 38 Studios case, the Attorney General got the materials from us. I don't remember if he subpoenaed them or he just asked for them and we gave them. But in any event, he ended up with everything. A lot of that ended up in front of the grand jury. And then the press was very aggressive to get the grand jury materials, which we had nothing to do with. That was up to the Attorney General, and it ultimately, if I recall, there was access to it. But that had nothing to do with the client, who in that case was the Commerce Corporation, or the Economic Development Corporation, whichever you go by. It was not their decision what to do with the materials that the grand jury had. They had no control whatever.
So in this case, the Economic Development Corporation would be the equivalent of the governor's office, or who would?
It would be the rough equivalent of the governor's office. The EDC was different because it was a freestanding corporation that could sue and be sued in its own behalf. The Department of Transportation is, in a legal sense, non-existent. I don't take that to it. It's part of the executive branch. Now, having said that, the interesting question, somebody's talking about, you know, what if we think that the Department of Transportation did something wrong here, which I'm not going to indicate is our belief. But it would be an unusual case if we sued any other entity if they didn't try to shift as much of the blame as possible to the Department of Transportation, all right? And we anticipate that if there is such a suit, that yes, there would be all kinds of claims made. So let me explain what our role is vis-a-vis the Department of Transportation. There is absolutely no sense in the state suing the state. The Department of Transportation is the state. It would be not much of a recovery, if you could even do such a thing. So, but we are interested in knowing whether or not there is potential liability for the Department of Transportation, because if that comes up as a defense, what the law in Rhode Island, I'm sure most of you know, is we have comparative negligence. So ultimately, if this goes to a jury, the jury would be asked, do you find that the Department of Transportation was at fault in any way, shape, or form? And if the answer is yes, then the question would be, what's the percentage of fault compared to everybody else? So if the Department, for example, totally hypothetically, if the Department of Transportation was responsible for 5% in the jury's view, then whatever award there would be reduced by the 5%. But no, we're not going to be suing the Department of Transportation because it's you don't sue yourself.
It kind of sounds like it's more important.
So-
If I could, excuse me one second, if I could add just one point to that. We've made it very clear in our investigation and our evaluation that the facts are what the facts are. We're not looking to filter any of that information as we go through the many tens of thousands of pages and try to evaluate, with the help of the experts, just what happened. We're not ignoring any piece of the facts. We're going to go where the facts lead us, and we're going to evaluate the wisdom of bringing a case based on where the facts lead, just to supplement.
Steph was starting to ask a very leading question, which was, it sounds like the desire to recover money is more important than the public's right to know. And my response to that, I thought I addressed it, but I guess not very well, is our sole interest, our only interest, is to recover as much money as possible. We honestly believe that in spite of the overwhelming interest the public has, to start disclosing what we know at this point is potentially harmful for that. So yes, the public certainly has enormous interest in this. But there are many situations where somebody's got to make a decision about whether or not satisfying the public interest is worth potentially compromising millions and millions and millions and millions of dollars of recovery.
So we go to Steve, Pat, not Josh after that, but he's just exit Steve.
What gives you confidence that early August is when you'll be able to wrap this up? Is that a self-imposed deadline? What hinges on that? That's only 3 weeks from now.
I say early August, right, okay. So I'm giving myself a little bit of leeway. Is it a self-imposed deadline? It's my best judgment of when I think this is going to be done, based on what I know about where we are in the case. I can't answer it any better than that. And when I come out and I say in front of you, early August, I really don't want to be in September with you guys saying, what happened to you know,
That's how that works.
Okay, I know that's how it works, and you're entitled to do that. So I am giving myself a little bit, I'm saying absent some startling revelation. And, you know, we haven't finished, but I'm giving you my honest best judgment.
Are you waiting on something? Is this internal work that you folks are doing?
It's internal work that
Okay.
we're doing. That is what we're doing.
Pat, Patrick, and then Gabrielle.
Two-parter. I've been intimately involved with in the litigation in the government against the governor's office and the Department of Health, so I'm very much aware of the discovery process and how it can get dragged out significantly. I'm also aware of the strategy where you bomb people with information while withholding the real kernels of truth that you folks need to find. So my first question is, has there been greater compliance with discovery both from the state but also from outside contractors? Has anyone given you any objections, or has anyone withheld information in your mind?
We haven't asked anybody outside for any information at this point, okay? What we've got, there's a lot of information about outsiders at the Department of Health. We have not asked outsiders for their internal memos, because we know very well what they would write back to us. Say, no, thank you, we're not going to give it to you.
If and when we get into the litigation
No, in the
process.
litigation, we would press that. But if we ask for voluntary turnover of internal records, you can imagine what they're going to say. It's just not going to happen.
My second quick question is, you've discussed, the potential between intrastate agencies, litigation between the two, it would make sense. But do you believe at any one point that there's potentially a case for cities like Providence, East Providence, at large, to have litigation against the Department of Transportation if in fact the Department of Transportation is found materially guilty to whatever percentage you are on?
Okay, I'm not going to address that question because I really have not evaluated it. And I don't want to give some off-the-cuff comment that I'm going to later regret. The answer is, I have no opinion at this point.
Patrick, Gabrielle, and then Alexa.
Going back, big picture, I know you're not going to say who or what or commit yourself to exactly what it might be, but it sounds like from where you're going, at this point in time, you feel like you have a case. Is that accurate?
I think way more likely than not, the answer is yes.
And are you looking at outside experts in addition to those contractors, VHB, VN, who have already been employed by the state to produce the forensic analysis and expert opinion?
Wait. I'm a little confused. The forensic analysis was not done by VHB. I'm confused by your
Sorry,
question.
VN,
What's the name of the company that's doing it?
WJE.
WISCHAN, sorry,
Yeah,
wrong acronym, it's my fault. Are you my question is, are you looking at other experts, other outside experts beyond who has already been employed to come up with the forensic analysis and those recommendations?
I'll answer it as follows. The WJE is a very large entity with many subspecialties within that entity. The person we're working with most intimately is working along with other experts within WJE. Once we have what we hope would be the final report, then at that point it's going to be a lot easier to go to other experts. We don't want to go to another expert now and say, hey, it's taken months to put this together, give us an opinion at this moment. It's going to take a long time. We want to be able to give them, if we go somewhere else, a package that they don't have to start from scratch. Let's put it that way.
And then also, I know you're not going to sue the Department of Transportation, the state suing itself.
Right.
But does that also cover individuals who may have been employed by the Department of Transportation at some time, or are they potentially liable?
Well, let's put it, let me answer it this way. We're talking about people who don't have insurance for this kind of activity. and would be, for a case like this, substantially judgment-proof. I haven't done an inquiry into their assets, but to start, in effect, us blaming if that were warranted, which I'm not suggesting it is, for us to start blaming individuals with very little capacity to respond would just be playing into the hands of other defendants. They would just say, look, the state itself is blaming its employees. So it doesn't sound like a practical or realistic approach from my point of view.
Would it be fair to say if you move forward with litigation, it will take longer for the public to find out what went wrong?
Then if we turn over our material, without a doubt, it'll take longer.
And if you do decide to move forward with a lawsuit, what are the next steps? How long do you expect that would take?
Okay, so what I don't want to say is, I know the governor said that the bridge that's going to come up is going to be last beyond our lifetime. I don't want to say that the lawsuit will last beyond our lifetime, but it's not going to be over in a month or two. What would happen in a case like this? I can't speak for the judges of the court, but they would get everybody in as soon as everybody was served and say, let's get a schedule going here. We can't leave this just floating around as if it were just, this is a special case and deserves special attention. And I can tell you this, we would be anxious to get it moving. We would.
So your hope as a judge would see the importance of this case?
I don't see any question that any judge would see the importance of this case. How aggressive the judge would be is something I can't speak to.
Alex next, then you, Steph.
I hate to belabor the point here, but early August, okay? Is this, you said it was very probable that you would bring a case, that you have a case.
Highly likely.
Is this the so-called day of reckoning that we're expecting in early August?
I don't know what you're expecting by a day of reckoning.
Well, that's what the governor's kept calling it.
Well, I don't want to speak for the governor. All I can tell you is one definition of the day of reckoning might be when these people are made to pay money. You know, I don't want to address what day of reckoning means.
Just to be clear, is it early August, is that when you would file the lawsuit?
That's what our hope is, yes.
Brian? And Chris?
If indeed we found it.
Yes.
And not to put the cart before the horse, do you have when you talk about maximum recovery, do you have some kind of sense of a dollar figure that we're talking about here?
Well, I don't know what it's going to cost to replace the bridge, number one. I think that was very much up in the air at this point, right?
So are you looking, is that a factor in it? Is there the replacement cost of the bridge?
Well, there's actually, actually, my brother here, by the way, lawyers call each other brother. I don't want anybody to think that we have any genes that are...
Twins.
So, he's reminded me, that was a very insidious question. I compliment you on it. I really don't want to get into that kind of detail at this point.
Chris Allen, and then we'll come back to you, Bill.
So I assume part of your inquiry has been interviewing rank and file or management at RIDOT employees?
To get documents, yes.
Have they been cooperating with you guys?
Yes.
Are they under any directive not to share information that they might have?
I hope the hell not, okay?
We've seen no evidence of that.
I mean, that is something that we would not stand for.
Is there anyone who's not been cooperative?
No.
Has anyone retained counsel?
Is it
Let me go to Bill.
Not aware of.
Yeah, we're not aware of it.
To Brian's question, it's not a class action lawsuit, so the public here, it's not like everyone's going to get a check for $27.42 at some point. But are there, as you move forward here, do you imagine, just so the general public understands what this is about, do you imagine that there will be any special attachments or distribution of those recovered dollars, or is it just going to go into the state's general coffers so the general public, the average person, doesn't even really feel an impact here?
Well, I guess you look like somebody who pays taxes. Are you?
Thank you. I mean, it's, you mentioned TikTok. I got this shirt on TikTok.
Do you live in Rhode Island?
Yeah, I do.
So you pay taxes. So obviously, to the extent the state pays money out, and it's, you're gonna be subsidizing that. So if we get money back, you're gonna get some savings in your pocket, that's for sure. So what else can I say? And by the way, if money goes into the general coffers, what to do with that? If somebody, if the legislature or the governor or somebody wants to disperse some of that money, that's not up to us. We have no role in that whatever. Our job would be done if, and we'd be very happy if we can deposit money into the treasury.
Chris Shane?
Yeah, I guess going back to the initial letter sent out to all these engineering firms, were they, if not, disclosed documents, have they complied with sending additional documentation then as part of this?
No, we've not asked for any. What we said in the letter is, please don't destroy anything. There's a concept called a litigation hold letter, where you can write to somebody and say, we're asking you to hold documents. And if we find out later that they've destroyed them after they got this letter, an inference can be drawn that there was something bad in those missing documents. So we didn't ask them to send it to us because that'd be bootless. Nobody, just inconceivable to me, that if we wrote to these people, please send us all your documents. There's not a chance in my mind, in a million, that anybody would comply.
Are there potential defendants outside of the 12 that you sent the letters to?
I'm not going to address that at this point.
Okay, how many of them inspected the bridge for your invitation?
At this point, I believe nobody has come in.
Oh.
I believe that's so.
Mike,
Can you
you
guys
wanna
verify
touch
that?
on
How far back do you think this thing goes? In terms of, how far back are you looking? You're looking at Benedict Arnold, how far back does it go? I think a lot of people right now see this in a very narrow lane, and it may very well be many, many administrations back.
Well, when you say a narrow lane, what do you mean before I answer?
Right now, you mentioned right out of the gate, the public hit that the McKee administration is really backed into here.
Oh,
The
okay.
scope of this
Okay.
seems to be, how could it be, it's not a year-long process.
No. What I meant by that, and I guess, I'm not used to press conferences, so I need to be a little bit more careful. What I meant by the hit was that, not that anybody's suggesting that all of this happened during the McKee, that's not what I meant. What I meant is, he's taking the hit right now for where's this report, where's this, what's happening, that's what I mean. Of course this goes back, without any question.
You have a rough time frame?
But that I'd rather not get into at this point, but it goes way back before the McKee administration, without any doubt whatever. I'm glad you asked that, because I've got to be,
Any last questions, guys? I think we're in the end.
How much have you guys been paid so far?
have we been paid?
How much have you been paid or reimbursed by the state so far?
So far, nothing. We haven't asked for.
Contingency.
How much have you?
Right, but we do get our out-of-pockets.
Yeah, like have you billed them? How much is?
We haven't billed
We
anything out
haven't
of
billed
pocket.
Have you expanded your team, added any paralegals or attorneys in this process, and would those personnel be?
We believe we're fully staffed and have the resources.
One more, guys?
Do you have
or
any
shall-
idea? Do you have any idea what it's worth, having this number of lawyers working together? All we need is some more.
That's part of our question, how many people are working on this?
We have 4 lawyers at the Savage Law Firm, and myself and Benjamin Ledson in my firm. So there's 6 lawyers and paralegals. We're depending on the Savage Firm to supply that.
Have you felt the need to depose anyone yet, or are you just more engaged in sort of a gentle discovery process?
We can't depose anybody without bringing a suit.
Okay.
Guys, thank you so much.
Thank you.
Any needs, last minute questions, just see me. Thanks again.
Thank you.